Afternoon, Alan. This is our third employment law podcast. You okay?
I'm well, thanks, John. Looking forward to it.
Yeah, good. You had a good summer?
Yeah, it was lovely. Weather could have been better, but hey, that's Britain for you.
That is Britain this year in particular. But one of the things that's happened in Britain this summer is that we've got a new Labour government, and they are going to bring in the biggest raft of employment law changes in at least 25 years, since at least 1997. For good or ill, they are going to do this. They have committed to bringing in a new employment law bill within the first 100 days of the new government, and we calculate that to be by the 12th of October. So it's relatively imminent as we're speaking. Keir Starmer is speaking at the trade union conference. There aren't loads of proposals set out in the, or details in relation to the proposals set out in the proposed employment law bill. And we are going to drill down to one of them now, which is this idea about a return to a 4-day week, which is a bit of an old canard if you're long in the tooth as we are, in terms of, is this what Labour governments historically deliver, a 4-day week? So we're going to unpack that. I'm just going to make one other big picture point, and it's this. I had lunch with a friend of mine who runs a lobbying company actually last week, and I said, what are the big issues for this government? And he said there are three. He said there is planning, there is the energy focus and what, wind turbines, etc., and there is employment law reform. So we are not flattering ourselves unnecessarily by having these podcasts, because the country is more or less broke. We all know that. The government has to be seen to be doing something, and therefore one of the three big issues in this government's agenda is employment law reform. It is coming quickly, and we're going to unpack one of the bigger proposals now. Over to you.
Thanks very much, John. So one of the bigger proposals, as you quite rightly say, is this move to a 4-day working week. Now, let's, from the very start, be clear about what we mean, or what the government mean about this 4-day working week. This isn't a reduction in hours. So in some instances, in some countries, we've seen a 4-day week go from maybe 40 hours to 32 hours and still maintaining the same level of pay. So you've cut your hours down maybe by 20%, but you're still on the same 100% rate of pay. This is not what's being proposed here. This is to do the same hours, but instead of spreading them over 5 days, spread it over 4 days. That will bring certain problems in itself for individuals and businesses. I'll come on to that in a minute. But the detail is not clear about how the government proposed to introduce this. Basically, an employee will have the right to request a 4-day week, and the employer will have to grant it unless they can prove that it's not reasonably feasible to do so. Those are the words, reasonably feasible. Now, we have no guidance. Mean? What does it mean? Yeah, there was no guidance on what reasonably feasible means. We currently have the right to request to work flexibly. And as we were discussing before we started the recording, John, this was introduced to everybody from day one, from the 1st of April. But there's a slight difference. I'll come on to that in a minute. But the current right to request gives the employer 8 grounds to refuse. And it's worth looking at some of those grounds, because I'm going to touch upon why I think they'll still be relevant in some respect later on. So, the first one is to do with significant costs. So if a change would involve significant costs, an employer can reasonably refuse. If the employer said it was would detrimental have a detrimental effect on the ability to meet customer demand, that can be a valid reason for refusing. An inability to reorganise work amongst the existing staff, that can be a reason, an acceptable reason for refusing at the moment. And on that ground, the government actually did use the word feasible. In other words, if it's not feasible to redistribute the work amongst current employees. So this feasible word is not a new one. We've seen it in previous legislation. If the employer can show that a change to working hours or working flexibly would have a detrimental impact on quality, that's another reason. Insufficiency of work during proposed work periods. So, if the way the work could be allocated would be inefficient, that might be a reason to refuse. And also if there's a planned structural change. So, for example, if there's an upcoming change planned to the business structure, that might be a reason to refuse. Now, those are the 8 reasons for refusing a current flexible working request as I say, we have no detail like that whatsoever in this current proposal. It's just that it's not feasible. But I think to some extent, employers will fall back onto these areas to say that it will cost more, or that we can't satisfy customer quality or demand sufficiently. I don't know what your view is that on, John. What do you think?
I think that's right. I mean, I think that will be the employer's default position. I think my concern is that it will reverse if this plan is to mean anything, because there are considerable rights to request flexible working from day one in this country already. And some employer commentators have said, well, this was a new right introduced by the outgoing government in April. So should we not let things settle down for 6 or 12 months before introducing yet more flexibility into the workplace? I think the new government is determined to do that. The question is whether this then reverses the burden of proof onto employers, so that there is a presumption in favour of the employee's request being granted, which is not currently the position. I think most employees think it's my burden of proof to demonstrate that I, as an applicant employee, can get over all of these 8 hurdles. But if it's the employer that has to demonstrate the burden of proof, then it could require the employer to demonstrate quite a lot, possibly by reference to statistics, I don't know, but certainly by objective reasons that they can decline this request. So I certainly think that it could give employees more leverage than they have at present.
Well, yeah, that's really interesting. When you mention statistics, it makes us think about figures, and I can see the employer perhaps having to produce figures, accounts to demonstrate what might happen. Now, that's an interesting concept, because you can imagine yourself in an employment tribunal, and one's competitors are looking at your figures that you're producing, and employers, in some instances, will be very precious about revealing those figures. I mean, they publish accounts, but you don't see all working figures, and there are reasons for that. So that could be quite controversial. It will be very interesting to see how an employer is expected to prove the position. Very interesting. And I'd like to look at some of the business impact as well of this proposal. I mean, there might be productivity concerns for those workers working longer hours, and potentially those workers who are maybe a little bit resentful of people who are only working 4 days a week. So there might be a little bit of unrest amongst the workforce there. There's going to have to be some operational changes, perhaps, in implementing flexible schedules. And again, that'll all be down to how feasible is it if the employer is saying, well, we really can't implement these new structures. And there may even be some potential need for additional staffing in some sectors. Now, to cover a role, is it not feasible? Is it not reasonably feasible that I have to take on additional staff to cover perhaps a Friday or a Thursday, whichever day it is you're requesting to have as a non-work day? I don't know, but these are all things we need to look out for, and it'll be interesting to see what happens.
And also, just thinking about it from a performance management point of view, I think there are benefits but burdens both ways. So suppose an employee says, well, I'd like to request compressed hours, and they succeed in that application. So they were working 5 days, now working 4. In principle, on an average working week, if they're a full-time employee, they're going to have to work between 2 and 2.5 hours longer to make up for that foregone day. So rather than finishing at 5 or 5:30, they're going to finish at 7:30. So that can add additional stress and complexity to that employee's time, because they're certainly going to be working longer on each of those 4 days. But in addition, the employer has got a right to then performance manage those employees over that time. So that employee might think, well, some employees will think, well, I can knock off really at 6 or 6:30 and they'll never know. But it's on the employer then to prove that employee's performance over those additional 2 hours per day.
Agreed. And what about supervision? If I've got staff working extra hours on certain days, I need maybe management in some instances to supervise. There may be authorities, sign-offs required from management.
Yeah, I hadn't thought about that.
It's not just a question of the individual carrying out the work in those extra hours. Somebody might have to supervise it depending on the industry. What do you think about that?
Well, that's a good idea, and I think suppose the manager's used to leaving at 5:30 or 6, and they might have, maybe for family reasons as well, and it's then on them to see whether they can manage those employees working longer hours. I read that Asda had trialled this in the last 6 months and had abandoned the proposal because they found that the additional shift times of working to compressed hours, as you say, it's the same amount of hours per week in a shorter time for the same pay. They'd abandoned it because the increased shift patterns were creating too much stress on the working days of those employees who'd asked for it. So there are pros and cons. I think it's been reported in the press, particularly the right-wing press, if one reads the Times, the Telegraph, that this is definitely going to happen, that this is all part of the Labour Party agenda and it's pro-employee. I think what we're saying is a bit more nuanced than that, is that it may happen, but it may not be necessarily pro-employee because it may not be beneficial to the workers concerned if they apply for it. But it also, as you said, may not be beneficial or fair on their colleagues and their employees as well.
Yeah, somebody's got to pick up the extra workload, cover the extra time, do the extra supervision. So I do think there's a lot of employee well-being, mental health issues at play here that perhaps haven't been thoroughly thought through. I don't know. Interesting to look at other countries, John, what they do. So Belgium
Yeah.
allows workers to compress standard 5-day working week into 4 days, which is what the UK is proposing. Typically, they work 4 10-hour days, which is incredible. I
Okay.
can't imagine having to work that. United Arab Emirates, but they're largely government employees. But again, they choose to work. Most people there choose to work a 4-day week. Iceland has seen widespread adoption of the 4-day work week following some trials over the last 10 years or so. Nearly 90% of Icelandic workers, I researched, now have reduced working hours each week. But those are reduced working hours. They're not just reduced days. And here, as I say, we're not talking about reduced hours. We're talking about the same number of hours in a shorter time. And that's what's going to cause the issue, compressing it into 8, 9, 10-hour days. And we'll have to see how that plays out. Lithuania, it's not a nationwide policy, but they do allow parents with young children to work 32 hours a week, effectively a 4-day week, although it can be spread over 5 days. And in France, they launched a national 4-day work week pilot in 2024, allowing companies to adopt a 32-hour week without pay cuts, building on its existing 35-hour work week legislation. So that's an interesting model. So same pay, fewer hours. As I said, that's not what's proposed in the UK. So those are some examples that illustrate what's happening certainly around the world. And it's very, very interesting. To what extent it'll become the employer's responsibility to prove that it's not feasible, we shall see. To what extent we will see claims, I don't know. Whether employees will wish to issue claims because of it. There could be discrimination, indirect discrimination issues could arise as well. What about a part-time worker? If they're working, say, 3 hours a day, can they spread their hours over 4 days? These are all issues that haven't been discussed, and we lack the detail really to make any specific observation on these. But interesting change.
Yeah, and I think you're right to look at the international comparisons, because clearly Labour is consulting on these changes, not just this change, but other changes that, we're talking about day one rights, and we'll probably unpack that in our next podcast, as well as other rights they are talking about the right to switch off, which is a right that is being trialled, I think, in Ireland and Australia. So they're looking at international comparisons, and they are very interesting. I think the thing I would say here, because I normally advise employers, is we already have the most flexible working culture of any country in the world, with the possibility of the United States. We have more 0 hours workers in this country than in any other country in Europe. And we already have a considerable degree of flexibility in the UK in order to ask for flexible working if one requests it. So philosophically, and I lay my cards on the table here, I query to what extent this is actually necessary or worthwhile, because the Zoomification of the world, during COVID, it might, one view as a Zoom or Teams save the world. It enabled us to continue to translate work, to do work. Look at how you and I work routinely in this way, and that creates flexibility. So there is technology and already enables a huge amount of flexibility in this country. Do we need an additional statutory right for increased flexibility? I'm not so sure, but it appears that the Labour government is going to go down this route. And the real question is, what's the burden of proof on employers? In terms of, will they have to prove a negative? And therefore, what are the knock-on costs for employers if this right comes in? What do you think?
Yeah, I think there will be significant knock-on costs for employers, but there's got to be some teeth in the legislation, John. Otherwise, this is pointless. So, but I think it's Labour demonstrating that they want to make changes and that they want to make some demonstrated changes, and I think that's why they're pushing it through, and that's why some of these things haven't been thought through properly. There will have to be consultation. I understand there's been meetings with some companies already. I suspect there's been meetings with unions, but I've not seen a widespread call for consultation on this point. And also remember today, we were only talking about flexibility in hours. We weren't talking about flexibility in work from home, work in the office type scenario, which is another kettle of fish. But that's not what this deals with. This is just dealing with hours. Of course, those could be hours working from home as well, couldn't they?
Yeah, and I think that probably the final thing, and this is not purely a sales pitch for those that are listening, but it is absolutely going to be the case that we are heading for the biggest employment law changes in at least 25 years. And, it's a point which you've made in the past and we've talked about, which is there are going to have to be changes in employment contracts, probably in the last, 2 months of this year. And also new policies that are going to be necessary in employee handbooks. So I think it's very difficult to conceive a situation where there won't be quite substantial changes to employment contracts or employee handbooks moving forwards once this new employment bill comes into fruition. And it's going to be fascinating to see what the Labour government introduces, because we've lived in a relatively static post-Brexit employment landscape for the last 3 or 4 years. We're going to live in semi-revolutionary times over the next 6 months. It'll be fascinating to see what happens.
Yeah, I agree, John. I mean, for geeks like you and I, geeks in employment law, it's really interesting, exciting times. Headaches for employers. But, things haven't been shaken up for quite a while. And this is one of the biggest shake-ups probably since about 1997, something like that.
Probably before then, I would say. I mean, Blair largely left things alone, but if they reduce the qualifying limits either to day one rights for unfair dismissal or even 6 months, that's a bigger shake-up than Blair and Mandelson did. So I think, people say, my dinner party point, my last point of this podcast, all that Keir Starmer, he's terribly boring. I always drift off when I listen to him. And I often say, look, actually, he's a quiet radical. Some of what he has proposed, particularly in the area of employment law, I almost envisage Citizen Keir, that this is someone who in his own mind is almost manning the barricades. And we're about to see now to what extent genuinely he is Citizen Keir, and we're going to find out in the next month, or whether actually he is quiet and boring. I query that.
Well, thanks, power Alan. To the people, John. Power to the people.
Let's see how much. Let's see how much power the people have in a month's time. Okay, nice talking to you, Alan. See you next month.
Great to speak to you. See you soon.
Cheers. Bye.